I'm Cynthia Rowland, and this is episode 85 of EO Radio Show. In this episode, I address the steps needed when a charitable organization has its tax-exempt status revoked by the IRS for failure to file the required information returns for 3 consecutive years. The forms required to be filed each year are the Form 990 series, that is, Form 990, 990PF, 990EZ, or the postcard return for very small charities, that's the 990N. Oftentimes, charities fall out of compliance not just with the IRS, but also with the state regulators, which may include state income tax filing requirements, as well as Secretary of State annual or biannual filings, and possibly filings with the state's Attorney General's office. Today's episode covers the road to recovery for an organization that wants to get back on track. Welcome to the EO Radio Show, your nonprofit legal resource. Brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. Many well-intentioned charities with attentive boards sometimes find themselves in the predicament that the IRS has revoked their tax-exempt status. Revocation can happen for a variety of reasons, and today we are focusing on the easiest one to remedy, that is, the failure to file the required federal information returns for 3 consecutive years. Organizations that are tax-exempt under Internal Revenue Code 501c often find out that they've inadvertently lost their exempt status by failing to file, but by the time they find out, it's too late for an easy fix. Sometimes years of non-compliance go by when the organization's key contact person leaves the organization or their address changes and the address at the IRS isn't updated, so the revocation notice never reaches the right people. Other times, compliance just falls through the cracks if no one involved has experience with all the technical regulatory requirements that apply, and then the organization is surprised to receive the ominous IRS notice of revocation. Or they find out from a prospective donor or grantor who checked the IRS database and found the organization listed as revoked. Fortunately, for an organization that continues to be organized and operated only for permissible charitable purposes, there is a path back to exempt status. Unfortunately, it's not always an easy path, but let's walk down that path a bit today, and I'll highlight the obstacles in the way of a complete recovery. First, the organization should make sure that it is still in good standing in the state where incorporated. In many states, that can be determined online by checking to confirm that all required statements of information or similar corporate registration and annual requirements are not delinquent, and that the named officers of the corporation are properly updated with the relevant state or states. Almost all states allow the filing to be done online and for a modest fee. So check your state's requirements and confirm that the organization is up to date. As part of that inquiry, the organization might discover that it hasn't been operating in compliance with its governing documents, that is, the Articles of Incorporation and bylaws. While compliance with those documents is not technically necessary to reinstatement of tax-exempt status, if the board hasn't been operating in compliance with its governing documents, now is the time to correct any deficiencies and make sure that the directors approve all actions taken in connection with returning to good standing with the state and with the tax authorities. Next, make sure that if the organization is required to be reporting to any state charity regulator, most commonly the Office of the Attorney General, be sure to find out what is necessary to bring those filings current if they're delinquent. Many state charity regulators have an annual reporting requirement that also requires a copy of the IRS Form 990. So if the charity has lost its exempt status for failure to file with the IRS, it's probably also delinquent with the state. Find out what is needed to become compliant by checking the applicable registration authority. Next, in states that have a corporate income tax, there is usually a parallel revocation that follows revocation of IRS exempt status, as well as revocation for failure to file the state information returns. If the exempt status has been revoked at the state level, an updated application for exemption with that state may be required as well. Sometimes the state revocation lags the federal revocation, so acting quickly when the federal status is lost may save the organization some headaches at the state level. However, if the state exempt status has indeed been revoked, that may trigger suspension of the corporate status as well. So it's very important to check all of these boxes to make sure that everything is on a path to reinstatement. So now let's look at the options for reinstating the exempt status with the IRS. Organizations whose tax-exempt status was automatically revoked because they didn't file the required Form 990 series returns or notices for 3 consecutive years can apply for reinstatement of their tax-exempt status. There's a specific revenue procedure published by the IRS, that's Revenue Procedure 2014-11, and it explains 4 different procedures for an organization to use for reinstatement. They can use any one of the 4. I've included links in the show notes to all of the federal rules and forms. So if you can't easily find them on the irs.gov website, check the show notes for links. So here's the first of the 4 procedures. This one is referred to as the streamlined retroactive reinstatement. And if organizations can use this one, it's very much the easiest path. So this streamlined retroactive reinstatement is used by small organizations with a very low level of annual revenue, and those organizations were eligible to file Form 990EZ or 990N, that's the e-postcard, for the 3 years that caused their revocation. These small organizations may have their tax-exempt status retroactively reinstated to the date of revocation if they have not previously had their tax-exempt status automatically revoked. So for this streamlined reinstatement, the small organization completes and submits a new Form 1023, 1023EZ, 1024, or 1024A with the appropriate user fee no later than 15 months after the later of the date of the organization's revocation letter that they received from the IRS, or the date that the organization appeared on the revocation list on the IRS website. It's important to note that the IRS will not impose the Section 6652C penalty that's applied to failure to file annual returns for these 3 consecutive taxable years that caused the organization to be revoked if the organization is retroactively reinstated under this procedure. So that's good news. If a small organization is able to take advantage of the streamlined retroactive reinstatement, the failure to file annual return penalty is not going to be imposed on those organizations, so long as they properly file the 1023 and complete and execute the paper forms 990EZ for all 3 of those taxable years. For any year in which that organization was eligible to file Form 990N, the organization is not required to file a prior year Form 990N or EZ to avoid the penalties. The organization should write the words retroactive reinstatement on the Forms 990EZ that they use to catch up for those 3 years, and they need to be mailed to the Department of the Treasury. The mailing address is in the show notes. So that's the streamlined retroactive reinstatement that applies to these very small organizations that act quickly within the 15-month period and that had not previously had their tax-exempt status revoked. So this second procedure, the retroactive reinstatement process for organizations that don't qualify for the streamlined retroactive reinstatement, works in the following way. Organizations that can't use the streamlined process, such as those that were required to file the Form 990 or 990PF, in other words, those that couldn't file 990EZ or the 990N postcard. So these are the bigger organizations. So these organizations can have their tax-exempt status retroactively reinstated to the revocation if they do all of the following 4 things. First, they need to complete and submit a new Form 1023, 1024, or 1024A with the appropriate user fee not later than 15 months after the later of the date of the organization's revocation letter or the date the organization appeared on the revocation list on the IRS website. So that's the same time frame as for the very small organizations that could use the streamlined approach. The second requirement here for these bigger organizations is that the organization must include with the application, that is the new Form 1023 or 1024, they have to include a statement establishing that the organization had reasonable cause for its failure to file a required annual return for at least one of the 3 consecutive years in which it failed to file. The third thing that these organizations need to do under this revenue procedure is they must include with the application a statement confirming that it has, in fact, filed the required returns for those 3 years and for any other taxable years after that 3-year period and before the postmark date of the application for which the required returns were due and not filed. So in other words, the organization has to complete its 990 forms before it sends in the 1023 form for retroactive reinstatement. And then the fourth thing that the organization must do is it has to properly complete and execute paper annual returns for those 3 consecutive years. And at the top of each of those returns, they need to include the words retroactive reinstatement. These paper returns have to be mailed to the Department of the Treasury. And again, the address for that is in the show notes. So when preparing the Form 1023 or 1024, the organizations using this procedure will see that there's a special schedule or checkbox that needs to be addressed for organizations that are filing this 1023 or 1024 more than 27 months after they were formed. These organizations should check the box for requesting an extension of time for filing the exemption application, and they need to include a reasonable cause statement as an attachment to that 1023 or 1024. Again, as we saw with the streamlined retroactive reinstatement, although there's a penalty for failure to file annual returns, the IRS will not impose that penalty for failure to file for these 3 consecutive taxable years that caused the organization to be revoked if the organization is indeed retroactively reinstated under this procedure. So moving on to the third procedure described, if the first 2 don't apply to your organization, this is the third option. Organizations that apply for reinstatement more than 15 months after the later of the date on which the revocation letter came from the IRS or the date the organization appeared on the revocation list on the IRS site, they can have their tax-exempt status retroactively reinstated to the date of revocation if they satisfy all 4 of the requirements I described above, except that the reasonable cause statement for the organization must establish reasonable cause for its failure to file the required annual return for all 3 consecutive years in which it failed to file. So it's a little higher standard here if the retroactive reinstatement is requested more than 15 months after revocation, and that is, you've got to show this reasonable cause for all 3 of the years that it failed to file, as opposed to the second procedure where you only had to have reasonable cause for 1 of those years. So organizations using this procedure should check the instructions carefully for how to indicate the reason for the request for retroactive reinstatement. The Forms 1023 and 1024 as currently written aren't exactly clear on which box to check and where to reference the reasonable cause statement, but there is a way to do that, and it's very important to be attentive to that in your new Form 1023 or 1024. Like the other procedures we talked about, the IRS doesn't impose the penalty for failure to file the annual returns for these 3 consecutive taxable years if the organization is, in fact, retroactively reinstated under this procedure. So for an organization that can't take advantage of any of these 3 retroactive reinstatements, the fourth option is to seek exempt status based on the postmark date of the application. So it's not a retroactive reinstatement. For seriously delinquent organizations that don't have a believable, reasonable cause statement, they can apply for reinstatement effective from the postmark date of their new Form 1023. So for these organizations, they complete and submit the applicable form, whether that's 1023, 1023EZ, 1024, or 1024A with the appropriate user fee. Sometimes this procedure comes into play when a charity was formed and attained exempt status, but never became operational, and has just been on the shelf for a number of years. It may be easier to simply dissolve and start over, but sometimes there's a good reason to keep the assigned employer ID number for the original organization, and all things considered, a postmark date exempt status may be just fine. That's the fourth option. So 2 final things to talk about in this episode. One is what's a reasonable cause statement, and then secondly, some best practices to avoid being automatically revoked again. So the reasonable cause statement is a statement that establishes that the organization exercised ordinary business care and prudence in determining and attempting to comply with its annual reporting requirement. The statement needs to have a detailed description of all the facts and circumstances about why the organization failed to file, how it discovered the failure, and the steps it has taken or will take to mitigate future failures. For a detailed explanation, take a look at Section 8 of this Revenue Procedure 2014-11. Again, that's linked in the show notes. So let's touch on how to avoid being automatically revoked again. The key here is to always file the annual returns on a timely basis. The tax returns are due on May 15th for calendar year nonprofit organizations, or the 15th day of the 5th month after the close of each fiscal year for organizations that file their return on a fiscal year basis. There is an extension period that's allowed, but that extension has to be requested before the applicable original due date. So the key there is to have an operative calendar that multiple people in the organization are copied on so that if one person leaves or is unavailable, someone else will be notified that these annual filing requirements are due. That calendaring should include not only the IRS requirements, but also any state exemptions, the Secretary of State filings, and any Attorney General or charity regulator filings that are required each year. So set up a calendar, have multiple people either on the board if it's a very small volunteer-run organization or staff members who are paying attention to these filings, and make this a high priority because loss of exempt status is just a huge hassle to reinstate. And the IRS has instituted these procedures to make it somewhat easy if caught early. It's still a big hassle. So that's all for this episode. Be sure to check out the show notes for links to the IRS pages on reinstatement. Also, Farella, Braun & Martel has a YouTube channel, and there are several nonprofit playlists for the EO Radio Show podcast that can help organizations understand their compliance obligations. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.